Good afternoon. Welcome to the Unemployment Law Project Monday webinar. My name is John Chirpak, Executive Director, and I have with me Ann Paxton, Attorney and Policy Director at ULP. ULP is a nonprofit law office. We give advice and representation for people with unemployment claims in Washington State. And today we will have an update from Ann Paxton regarding current events with unemployment insurance, and then we will take your questions. Put your questions in the Q&A, and Ann, you can begin. Thank you.
Thank you, John. Good afternoon, everyone. Thanks for tuning into our webinar. We want to just briefly go over some things that are happening to update you. The interesting thing is that there was a big expectation that with the end of the federal programs, PUA, PUC, PEUC, around September 4th, depending on the state that you're in, that there would be a drop in unemployment claims. And there was a slight drop, but then suddenly they started going up again. So that's kind of a big story because it's contrary to expectations, and it sort of bears out the suspicion that the Delta variant and other factors are creating more layoffs. So right now there are still about 12 million people in the country who are receiving jobless benefits. And it's still, we're getting some of the worst showings in the labor market, although Washington actually has added more jobs than was expected. Last month, there were a new 16,000 jobs. Most of those were in the entertainment, the health and leisure and hospitality center. So our unemployment rate is slightly better. That is lower than other states. But the news, we're not expecting there to be brilliant news coming down the pike because of so many factors that are making the surge in COVID infections, surge in COVID deaths, and new variants out there. They're creating a lot of uncertainty and a lot of fears that there will be increases in unemployment. So one issue that has arisen along with these factors that are making the pandemic look like it's not recovering as fast as people hoped is the possible extension of the federal pandemic benefit programs. When over the last several months, the Biden administration has talked about its feeling that they wanted to let the programs expire. They encouraged the states to use the administration money that they've been receiving under the CARES Act to possibly have their own extensions because that money is available. But they did not want to extend the federal programs. And some Democrats in Congress, including led by Alexandria Ocasio-Cortez, have said they are planning to introduce some legislation to extend those programs, but there's not a feeling that there's not a strong feeling that those have a lot of prospect. But there is a strong feeling that the way unemployment has spread and the way the system has failed to help people has had an especially strong impact on Black and brown communities. And even though the Democrats did not opt to extend the program before they expired, there's still a strong feeling that they need to do so, and that there's fear that the entire federal unemployment system will become weaker as states put in further reductions in benefits. Not so much in Washington State, but in about half of the other states. There, as everyone knows, several of those cut off their benefits early. And there are other plans not to give further support to claimants. The National Employment Law Project has been one amongst other major leading organizations that have said this is a glaring omission in the spending package for the 2022 budget at the federal level, and they are urging that unemployment insurance reform be included in the measures that are being debated right now in that $3.5 trillion package. An interesting set of hearings took place at the Employment Security Department a week or two ago involving a new planned program that's embryonic right now, but could be could develop over the next year or two, and that would give benefits to immigrants in Washington State who may not have documentation of their immigration status. So the ESD held a couple of listening sessions, which were very interesting, because they gave people a chance, most of them undocumented, to be heard in a very unstructured framework where they could comment on the possibility of getting benefits and on what kinds of issues they'd encountered when they dealt with past benefit programs through the state. So a lot of these comments would have been pretty predictable in a lot of ways, because they're very similar to what claimants in general have been saying about programs, that the problems they encounter with the benefit programs, especially in unemployment. And so one of just a few things that I wanted to mention that were interesting was the element of intimidation in the application process is, of course, much worse for people with a language barrier. And immigrants were very concerned about that, and about the absence of respect that they expected, that they had encountered in various other benefit programs in the state. For example, workers' compensation is available to undocumented workers who are eligible, but it is not available because of federal restrictions in the unemployment program as it exists now. This would be a separate state program that would be geared to undocumented people. But they said this is how people fall out and give up, because of this absence of respect and intimidation. And they would like more assistance available when they apply, and better services when they actually do start getting benefits. Some of the people who testified have special needs children. Many of them obviously have language barriers. One typical one in Spanish, for example, that is not really accommodated for in the current unemployment system, even for people who are documented, is that there are many Spanish names that have two last names. So the system doesn't necessarily accommodate that. Various things that are also that this group also has in common with other current unemployment benefits. Some people live in their cars. Some people have other very restrictive economic conditions, and that there needs to be a stronger state safety net. That was a very common comment. The system is hard to figure out, even for college graduates. And several other barriers that this group faces are very well understood by people already receiving benefits in the unemployment program. Lack of efficiency in responding to applications, weeks or months without any kind of benefits, correspondence needed in the person's individual language, and systems that are fair and available for everyone. So these are things that the Employment Security Department is working on in general, but it was interesting that they did have these listening sessions. They did hear what people's comments were, and they are laying the groundwork for a potential program that would be helpful to so many workers in our state who are undocumented and do face the same levels or worse of unemployment, and the reality of being without any benefits or basic income support during those periods is very serious. So there are several current issues I wanted to mention briefly that we are discussing with the Office of Administrative Hearings about the application process, about adjudication process, and appeals. And one of the major ones is, in fact, an interesting development that occurred when a judge recently, and I'm sure this happens often, but we don't actually see all of the decisions that come out from the Office of Administrative Hearings, just the ones that involve our clients. But this was a recent decision. It was a dismissal of an appeal that had been, and it was sent back to ESD because there was no basis for the determinations that were at issue in the appeal. Well, what does this mean? This means that the person whose benefits were denied got a determination from the Employment Security Department, but there was effectively no statute or rule that was cited as the basis for the determination that is the denial. So as a result, there was no effective due process received by this claimant, and the judge sent the appeal back to ESD to prepare a proper determination. So we hope this is going to happen more often because we've seen this happen in many cases. In this particular case, it was very egregious because the case involved a denial of federal benefits under the PUA program, and the public law that was cited as the basis for the determination or the denial was the entire 335 pages of the CARES Act, which is such a massive document that it could not possibly have any meaningful status as notice to the claimant to explain why they were being denied benefits. So it's encouraging that that denial actually occurred. So we're hoping that more of that will happen. And we're also very concerned about things like when people get an overpayment, there's not enough information for them to understand what the source of the overpayment is, because there's very little explanation available on exactly how the amounts were determined. Even when people successfully contact ESD, many times they're unable to get this information. So that creates a problem when an important determination is made, is whether the claimant is at fault in their overpayment. If you are at fault, for example, you're not eligible for a waiver of the overpayment. That is, you can't get a pass on paying that. So it's a very important status, but it's very complicated by the fact that there's no information, often very little information available to decide whether the person is at fault. In many cases, they are supposed to be assumed to have the understanding of how much money they were owed in a benefit, and they should have known better. They should have reasonably known that they shouldn't have gotten a certain amount of money because they weren't qualified for that. But that is not at all the case. For many claimants, they have no idea how benefits are calculated, and there's very little information available on that in their individual claim information. You know, if we had more time, I would show you this very interesting dismissal, but it's very technical. I did want to mention it though. So another thing that we're very concerned about that I want to mention is the mixed earner benefit. This is something that was announced last January. It was part of the Continued Assistance Act, along with the extensions of PUA, PEUC, and the Pandemic Unemployment Compensation add-on. Mixed earner benefit is for people who have in their work earnings history have both W-2 income from employment and self-employment income. Unfortunately, the way the system has been set up, you aren't allowed to combine those in order to arrive at a benefit amount. So that means you could either qualify under your W-2 income to get regular state benefits, or you could qualify under your self-employment income to get PUA, but you weren't allowed to combine the total amount. So as a result, many people, called mixed earners, were getting way less than they should have based on their income. So Congress passed a mixed earner benefit along with the other extensions starting in January, and Washington State actually opted into this, but it has mysteriously dropped off the grid. We have not been able to find any information about applications, about approvals, about any benefits being received in the state, and we can't find anything on the website. So this is a big mystery. We're trying to get some information about. Washington is one of the states, as you know, that did not end the benefit programs early, but on this particular benefit, this benefit never got started, and that's happened in a lot of states. It's not clear why, but the money is still available for people who are eligible during the period between January and September, when all the benefit programs came to an end. If those application processes are started, they should be qualified. People should be able to become eligible, where they are eligible, for those benefits over the months that they have not been receiving anything. And then finally, just one small but significant development is there are some new draft regulations that have come out from the Employment Security Department on making improvements in the process by which people can file appeals. And one of them is will be allowing the filing of petitions for review. That is the first level of appeal after a person loses their hearing, by email. So that maybe should have been something that could have been adopted several years ago, but it's good that it's being announced now. It is possible to file a PFR, petition for review, through your e-services portal. However, this can be um, somewhat of a trap, because many times people think they're filing a comment about their loss of an appeal and it turns into an actual petition for review. Then they may come for help to the Unemployment Law Project or another legal group, and they can't get it because their PFR, petition for review, has already been filed. They didn't even mean to file it, but it was already filed. So that's a little bit of a danger that can occur with online filing. But email filing is going to be very helpful to a lot of people. More space for backdating requests to reopen claims, that is after you haven't filed for 4 weeks. Right now, backdating can be difficult, but that they want to make that easier. And also a rule that would let the waiting week continue to be waived. That is, people would not have to wait a week in order to get their benefits when it's federally funded fully. Right now, that has to actually be approved by the legislature, so it would become automatic. So it seems like possibly a small thing, but it can be very significant when unemployment is rising and people are really needing benefits in a very urgent way. So that is the news for this week.
Thank you, Ann. The issue of filing petitions for review, this has been an issue for years, where a person who loses their hearing, let's say they were representing themselves, wants help from Unemployment Law Project or another law office, and they don't realize that filing their own appeal sets the action in progress. And a lot of people naturally assume an appeal will be a new hearing, when an appeal is a review of the hearing recording and review of the paperwork with that claim. And that there's, in most cases, well, in 99% of cases, not a new hearing. There are a couple exceptions where it does come back for a hearing where there's a problem with the audio, or perhaps there was something that happened in the hearing procedurally. For example, a judge excluded certain evidence or didn't consider something important, where it gets sent back for a new hearing. But in most cases not. So it's important, if people do want to appeal, there is a 30-day deadline. So there is time, is not to immediately appeal if they're seeking help, because you can't essentially add to your appeal that's already filed. Before we take questions, and please put your questions in the Q&A. I already have a few questions. I would like to comment on an issue that we've seen some questions out in the last few weeks. There are vaccine mandates now, and people want to know, if I get fired for not taking a vaccination, or if I quit, will I get unemployment? And I'd like to address that briefly. There are no special rules in place that I'm aware of regarding vaccinations and unemployment. Vaccinations are widespread, they're easy to get, they've been proven safe for most people. There are some rare medical exceptions there, but it's safe, and the public safety issue is extremely important. Now 1 in 500 Americans has died from COVID. With the rise of variants, it's still a major public health crisis, and will continue to be so for quite a while, years, I believe. And so if a person refuses a vaccine, most likely it would be viewed as insubordination, because it's failure to follow a reasonable rule. If a person did put up sort of a religious defense, that's a possibility there, of course, but most major religions, if you look at the Catholic Church, mainstream Protestant churches, others, Jewish faith, they support vaccination. There's been some misinformation about the origin of the vaccine, but again, the Catholic Church would not be supporting these vaccinations if it went afoul of their philosophies. Now, there's an issue of safety. for individual medical providers, I think it would be advisable if somebody did have a serious medical issue to get written documentation about that for the employer and ask for accommodation first, because there may be an accommodation there for you to have your job modified in some way without a vaccination. Under the quit statute, there's quitting for good cause for medical reasons. That's a possibility there. Again, documentation would be essential. But quitting due to moral or ethical or religious objections there is more problematic. Some people I've talked to in recent weeks who claim a religious exemption, when you really speak to them, it's really a political objection. I don't think that will fly. I would urge people to be vaccinated when they can, so they keep their jobs and to avoid spreading the virus, because it's not just a personal choice for you. It's the fact that you can get it and then transfer it to other people is quite serious, especially with young children if you work in schools. So now, is there any history on this? Of course not. We haven't had a pandemic since unemployment began, so we don't know how these issues will play out. Currently, it takes a while to get a claim processed, and it takes months to get a hearing, maybe 6 months to get a hearing now. So theoretically, if somebody is fired or quits in October, they might not know for months, maybe till December, if they will get benefits. And then if they're denied and they request the hearing, they may get a hearing months later. One thing that is a big issue is that if people do, even if a person did quit and or was fired and somehow did get benefits, that is only a temporary solution, since a benefit claim will only go a few months. And with vaccine mandates being widespread, a person in that position would have to really seriously think about reconsidering getting vaccinated or finding some other line of work that would not require vaccination, because unemployment is only a temporary solution, even with extensions. So we will continue to get questions about this. It's hard giving people advice about what could happen or might happen, especially since there isn't that specific history, but it is an important issue. And on our website under COVID-19, we have some information posted there that we put together. So let's go to some questions now. The first question is from a person who was recently laid off and who is getting benefits and wants to know how many weeks, how long they will continue to get benefits. So this is a regular unemployment claim. The basic unemployment claim is 6 months, 26 weeks. And are there any current extensions for regular unemployment benefits right now?
No, as of September 4th, the PEUC, which was available as an extension for regular benefits, is no longer available. Extended benefits is not in the picture right now either. So there are no extensions current. Only the 26 weeks are available.
So it's important for anyone getting benefits to seek work and to become reemployed as soon as possible. 6 months can go by pretty quickly. And if the status remains the same, there would be no extension. And again, in searching for work, it's good to be open-minded, but don't accept things that you know you can't do or would have to quit, because that will mess up the claim. But the job search requirement is back as of the first week in July. So a person must be fully able and available and actively seeking work for each week claimed. Okay, so let's see. Next question is, this is a familiar thing. I won my hearing a week ago and I haven't heard anything. What should I do? I'm assuming the person was owed money. It was a denial of benefits. I've been talking to people that it takes a couple weeks for them to process a claim. If you wait more than a couple weeks and haven't received anything, call the 800 number. Keep trying, getting through, saying, you know, I have a hearing decision, read the docket number of the hearing, and then ask if they can look into it. In most cases, it's just a processing delay. There are a few cases where there may be another issue holding up benefits, and that can be found out. If that doesn't work or you can't get through, contact the governor's office, your state senator, and state representatives. Let's see here. Let's go to see if there's other. Let's see. We have a question here. Let's see. As I went to submit my claim in e-service, I noticed that there was an alert indicating overpayment. With that being said, there was not an explanation letter within my e-services letters, messages, or by U.S. mail. How should I proceed? Thank you. I believe ESD should be mandated to provide a letter as to why the overpayment. Yes, that is what the law states. There should be a due process, right, of what the overpayment is, how much, and including your right to appeal, and with instructions on how to appeal. And we've seen problems too with the amount of overpayments that Ann had mentioned, because sometimes when they send the overpayment, or most times when they send the overpayment letter, they will talk about a base amount. But for most overpayments being processed now, people receive some sort of pandemic supplement, whether it be 600 or 300 for various weeks. So that's why those numbers are off. I would follow up by calling the 800 number. If you can't get through, again, call your state senator, your state representatives, there are two, and the governor's office, and ask. You could try submitting a general letter of appeal, but it may or may not be processed if it's not attached to a specific denial. Ann, would you have anything to add about that?
Yes, I just put in the email address for the Benefit Payments Control Office. You can contact them and say you have no notice of the reason for an overpayment. You just received this in a vacuum, and you don't know what to do with it. That is at least one thing you can do. And as John mentioned, you have a perfect right to have the reason for the overpayment known to you, because that is what you need to appeal, not just the overpayment itself and your ability to pay it off. So you have to persist and say that you cannot even look at this if it is a demand for payment until you have a reason given to you for the overpayment.
Okay, let's see. Next question. A person received a lump sum payment. It was confusing because some of the weeks included deduction with the word intercept. There was no explanation of the word or deductions, but I found out by sending a question through SAW. The answer next day was, this is primarily due for taxes, a possible overpayment. Does the ESD have a right to deduct 10% for IRS? Remember indicating, there are deductions for various reasons, and I'll give a long answer on this just because it may impact a lot of people. In general, most of the time when there's a deduction, a person would have opted to prepay some taxes. Before Reagan was president, unemployment was not considered taxable income. That changed, unfortunately, in that period. And it is now. And so most people, to avoid a big tax bill at the end of the year, will opt to have that. So a person should have that as an option, and perhaps it was indicated accidentally or not, contacting ESD to find out if that's not something you want. In general, it's probably a good idea to have an IRS tax deduction, just because avoiding, it's better to get a refund next year than have to pay taxes. Another deduction is for overpayments. A lot of time people are not even aware of an old overpayment. And I'm being very general here, not to this specific question here, because there's a lot of possibilities that people will have an old overpayment, even like, sometime 5-10 years ago, somebody might have been denied for 1 week or something, even a few $100s. That will be still in your system. And even if you have a valid new claim, they will collect out of it a percentage. And then the other reason I've seen some deductions, and this is pretty rare, is people with some child support obligations. That comes up occasionally. And I don't know whether that's voluntary or not, whether the person opts in to have back child support paid through deductions, or whether that's a result of court action. But that is a possibility there. So in this particular case, the best action is to try to find out what it's for and see if you agree with it or not. Or whether it's an error. There are some possibilities there, but they can deduct out of it, just like wages can be garnished for various reasons. Okay, and any comments on that, or anything to add?
Yeah, just want to add, this is a complication of overpayments and getting a waiver for an overpayment. Once the money, for example, if you had a $5,000 alleged overpayment and $500 of that went to the IRS for the 10% withhold of your taxes, that you cannot get that $500 back, $500 wiped off of your overpayment. You can't get it waived. That money is not coming back to you. Same thing with child support. So this is just one among many, many complications of trying to understand what the overpayment is all about. Why are you getting charged all this money? Why are things appearing there that you never expected? And why can't you get some of them even considered for waiver? It can be very, very complex. They need to have better procedures for letting people know how they're calculated and how they can be waived.
One thing about, well, I agree that money's not going to come back from child support, but depending on your individual tax situation, it could come back to you as a refund, depending on your income for the year and number of people in your family, things like that. So it's possibility that it's there. It is credited to you. And even if you had like the rest of an overpayment waived, the fact that some of your income tax has been prepaid may end up being a benefit to you,
Yes, sure.
just in terms of logistics in April, because come tax time, I know there are some people with regular income who know every year how to do their deductions and what they pay or what their refund is, but with the pandemic and with income being broken up and people getting earned income unemployment, it can be really hard to know what your tax, whether there'll be a refund or you would have to actually pay taxes. And it can be quite shocking for people who, do their taxes in March or April and find out that they owe thousands of dollars based on their income. So prepaying is always a good idea there. Okay, so let's see. A question about appeals. I think I touched on this earlier. Person writing requested an appeal. How soon will it take to get my hearing? Common question we get. Office of Hearings hired more judges. They've hired more staff, and they're even having hearings sometimes in the early evenings and on Saturdays and Sundays now. But they're still behind by thousands and thousands of hearings. Our office gets hundreds of calls every day. There's an extreme backlog. A lot of it has to do with overpayments from last year. So you can imagine, volume they're dealing with. I've heard different things from different people. I talked to a person recently who said they called the hearing office and they said that their appeal was received from Employment Security, but their hearing probably wouldn't be scheduled until March or April of next year. Now, it could be scheduled sooner. So anyone who's requested a hearing should keep their mailing address current, check their mail. If you're going to go away for a few days, have somebody open your mail for you. And you can call the Office of Hearings, Office of Administrative Hearings, has an 800 number, 800-366-0955. That's 800-366-0955. And you could ask the clerk if they have your appeal and when it might be scheduled, to kind of give you a more general idea. And if you're seeking representation, you can ask at that point or later on to have your file sent to the Unemployment Law Project, and then contact to set up an intake interview. But it's important to, because we're dealing with hundreds of thousands of calls in a month, it's important that people, even if they're seeking help from Unemployment Law Project, to not rely, to monitor the scheduling of the hearing themselves very closely, because it's impossible to keep track of thousands of hearings. And so that when your hearing date does come, you can contact our office back as it gets closer and scheduled. It can come up quickly. Hearings are usually scheduled on a couple weeks, but if you're not checking your mail, you might open the envelope and see it's scheduled in 3 days. So it's important to, it could be postponed for representation, but wouldn't you rather, if you've been waiting months, just get it done as quickly as possible? And a postponement would take weeks. Let's see, Anne, anything to add to that?
No, I think you covered it.
Okay, I have one more question. It looks like I can wrap up after that. The question, it's kind of complicated. It's a family member. It's for a family member. Again, this is a similar question, that they are getting bills for overpayment and they don't know how or why they're getting the bills for the overpayment. They closed their claim months ago and are back to work. And they try to go into e-services account and they're blocked from getting in there. What to do there, how to find out. And do you have any thoughts on that? Somebody blocked out of their account.
Right. This is very common, unfortunately, and it's very difficult to solve. The only realistic solution, and it's not a very good one, is to do your best to get through on the unemployment claim center line, the 1-800 number. Even though this is very time consuming and frustrating and is going to involve many minutes or hours on hold or hangups, there really is no one else who can fix this for you unless you get through to them. Now you can always you can always turn to the option of getting hold of your legislator, writing to the governor, and so on. But this, in terms of a practical answer to getting some action in terms of your access, this is really about the only thing that can work. So we really strongly recommend it. We wish we could help. Our ESD staff is 1,700 people. Our staff is more likely to be in the single digit. So we're doing the best we can, but this is something we can't help you with. You've got to get through to the secure access assistance line or the claim center number to get it fixed.
All right. Thank you, Anne. So that's it for questions for today. Thank you all, and we will be back next week with another Monday webinar. Thank you.
Bye. Thanks.